Hello, everyone, and welcome to Thursday Talks with Chuk. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chuk Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming partner and attorney Maureen Scorese from our Edison, New Jersey office and legal consultant Prateek Tiwari from our Hyderabad, India office. Hi there, Maureen and Prateek, and welcome.
Thank you. Thank you, Ariane. It's great to be here.
For today's talk, be talking all about data privacy. Just a quick disclaimer before we get started, I'd like to remind you that this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please comment them below and we will get back to you as soon as possible. You can also email us at info@chuk.com. So let's start with data privacy and breach exposure. Prateek, can you tell me how do evolving privacy laws like GDPR and the California Consumer Privacy Act impact small and mid-sized companies in the United States?
There are like various consent requirements in GDPR and CCPA. So CCPA is quite liberal, like they have expensive consent requirements. There is a opt-out rights for consumers. They can opt out of the sale of their personal information. But in GDPR, it is quite narrow and there is no opt-out provision there. Consent must be informed, freely given, and revocable. And this is very different from the US laws. Now, again, there is also severe penalties in GDPR, but it is subject to GDPR has stringent penalties up to 20 million or 4% of a company's global annual turnover. However, CCPA has no such percentage requirement. It's just a specific dollar amounts per violation. That's it. Like these are just two basic compliance requirements for small and mid-sized companies in US concerning GDPR and CCP.
Oh, wow, good to know. So I know we have a lot of clients who have companies both in the US and in India. So how do the enforcement mechanisms differ between the US GDPR and India? Can you tell us a little bit about that?
So enforcement mechanisms are there are compliance officers in all jurisdictions in US, in UK, and in India. Now their powers and their jurisdiction varies based on the reason. So in India, there is a data protection officer. He has to do data protection impact assessment and do audits. And there are penalties reaching up to $33 million for violations. And like Indian Digital Data Protection Act is very specific, its purpose is specific, and consent is more has more heightened requirements for children and persons with disabilities. In UK, again, similar terms with India, like they have Information Commissioner Office, who is responsible for overseeing compliance, and like they have to notify the breach within 72 hours. And post Brexit, there has been restrictive, like strict compliance requirements. And like in US, like US don't have any single comprehensive federal data protection law. They have a very fragmented structure, and they have sectoral laws like HIPAA, like for health information, and state laws like California Consumer Privacy Act. So these fragmented provisions in different states, all states have different privacy protections, but most comprehensive is California Consumer Privacy Act. And consent requirements vary, but the authority which oversees compliance is Federal Trade Commission and state attorneys generals in respective states. That's it.
Oh, wow. Thank you for breaking that down for us. What about children's data? I'm curious, are there differences in how children's data is protected?
Yeah, like US has Children's Online Privacy Protection Act, and it protects children under 13, and it mandates the data minimization and prohibits targeted ads for children. But however, UK and India has quite age limit has been extended, and consent age for children is 16 years in UK, and in India it is extended to 18 years. And Act also Indian Act actually specifically prohibits behavioral tracking and targeting advertising like children. So Data handling is same in all regions, only is the age-specific criteria is differing in all three jurisdictions.
Oh, wow, really important information there. Can you tell us what the requirements are for transferring personal data out of the country in each region?
India allows cross-border because yeah, we all know that it's a global world which is globalized heavily and we have to deal in trades and also yeah, India also of course permits cross-border, but yeah, we have to make sure that government actually publishes a negative list, restrictive list. So companies have to like they have to abide by that, and the cross-border transfers are allowed, but there are no clear or adequate contractual clause framework for multinational firms. So that's where India lags behind. Like government is working on that, and UK also allows cross-border transfers with adequate protections, and there are various corporate rules. And like UK has a very good cross-border transfer of personal data, which is allowed for multinational firms, and it is very it's not there are not much hurdles for multinational firms. And the USA also permits free data flow, but faces scrutiny over privacy advocacy from other jurisdictions. The reason is USA has a very fragmented structure, so other jurisdictions have doubts regarding each state specific requirements in US.
Yeah, that's a great point. If you are watching this and have any questions about this, feel free to reach out to us. We're always happy to guide you here. So, what are the fundamental principles of data privacy and how are they applied in practice? For example, we're talking about lawfulness, fairness, transparency, purpose limitation, data minimization. Can you give us some information about that?
Sure. So what happens is like there are compliance oversights, like oversight officers in different jurisdictions who ensure that there is lawfulness, transparency during data privacy. So as I discussed, that US has Federal Trade Commission, UK has Information Commissioner's Office, and India has a Data Protection Office. Now, the what happens is like there is a in India there are several sub like hierarchical structure for ensuring there is data privacy. Like they have regulatory authorities which actually give out like quarterly reviews or reports or audits to different firms, like what has happened here, like where are the breaches, where there is lack in enforcement, and there are very regulations which are in form of laws passed by these regulatory authorities. UK also has same, and like here organizations must report breaches within 72 hours and demonstrate compliance through documentation and impact assessment. So impact assessment is also a very common practice, privacy impact assessment, which is in India, UK, and US. And in US, like state law, most of the state law provide additional enforcement mechanisms. So this varies by state to state, but the most uniform law is California Consumer Privacy Act, and that has the like comprehensive enforcement mechanism. That's it.
Oh, thanks for sharing that with us. Can you tell us how organizations demonstrate accountability for data processing and compliance with regulations like GDPR or the Digital Personal Data Protection Act?
So there are common principles which every organizations can adopt, and this is very common to all three jurisdictions. The differences are there, but I will discuss the common practices which are adopted by most of the multinational firms across the globe. So first is like appoint a senior executive or governing body responsible for data protection, provide adequate budget, staff training, like train your employees. There should be a written data protection privacy policy. You should have a procedure for handling data subject requests, incident response, retention. Third party management is very important, like there are vendors also. Then there should be a standard operating procedure for pseudonymization and other things. Then there is maintain a record of processing activities. Data flow diagrams should be there, how data moves through the systems and ensuring the security. locks of systems, access control, audit trails, conduct data protection, impact assessment, or privacy impact assessment that I already told, like in US, UK, and India, data protection impact assessment is done by the compliance officers of all these three jurisdictions. Do risk assessment of vendors, third parties, periodic privacy and security risk reviews. Written contracts should be there, and you should publish your accountability and transparency reports regularly. Publish summaries of assessments, audits. Like in Indian regime, there is additional points to be concerned. Like in India, rules require breach reporting within 72 hours. There are significant data fiduciaries in India. They have additional obligations. They must appoint a data protection officer, a data auditor, and carry out periodic audits and assessments. So in India, it's a unique concept where you have to appoint a data auditor also. And even if when data is processed by third parties, fiduciaries have to maintain oversight, audit rights, and binding agreements. So, and Indian law's accountability is not merely aspirational. Specific structural requirements are placed on high-risk players. Yeah, that's it.
Very thorough answer, thank you. How do different national and international data privacy laws, for example, GDPR, CCPA, the DPDP Act, compare in their approach to key concepts like consent, data processing, and individual rights?
So consent is like consent is very limited in CCPA. There is opt-out model in many cases, and it emphasizes transparency and choice. GDPR treats consent as a default requirement. It should be very explicit and freely given. Same goes in India. Like India is very has adopted a law very closer to GDPR in forms of consent. There is also a rights-centric model, like they emphasize on the rights of the consumers and they should not process data which goes against the rights of the consumers' consent. And and GDPR is very expensive and it provides expensive set of rights. And Indian law is also same. CCPI rights are narrowed and it focuses on access, deletion, opt-out, and that's it for this. Yeah.
Great. So for a business owner, how do they get started implementing their program to comply with cyber and privacy laws and regulations? And should they invest in security products? What advice do you have?
So best way to get started implementing programs to comply with cyber laws and is to get acquainted with the local laws and get yourself more aware of the recent developments. Like there is basic framework which I will say like what data do you have? Like do I have? You just need to find it out. What data do other people in my organization have? How will I collect the data? How will I secure the data? How will I share the data? So these are like 6, 7 points that you have to be very cautious about. That's it, Arianna.
Wow, really good. Thank you. So can you tell us the EU and US data privacy framework and what its implications are for cross-border data transfers?
So, like what happens in EU-US data privacy framework is a regulatory framework, and it aims to establish enhanced protections for cross-border data between EU and US. And it was developed in response to concerns raised by European Court of Justice regarding Privacy Shield Agreement, which was invalidated later. And this framework actually provides a mechanism for companies to demonstrate compliance with data protection principles when transferring personal data between EU and US. So it enables US companies to self-certify their adherence to the requirements and allow them to receive personal data from EU. So this is a mechanism which ensures quick and transparent working of these privacy laws. Yeah.
Perfect. One last question for you, Prateek, before we go over to Maureen. What are some data privacy risks of using artificial intelligence? Please enlighten us here.
Yeah, so this is a very recent development. Like everyone is very cautious of artificial intelligence nowadays in data privacy. What happens is, like there is data collection. There is obvious. There is it can be misused. It can be re-identified. There is a chance of surveillance and profiling. There can be manipulation of data, and there are biases and discrimination in this. There can be vulnerability to breaches. So yeah, so like what happens with artificial intelligence when you are using OpenAI or ChatGPT, you are giving lots of data to them, and it can be profiled or it can be modified to suit their own needs. So that's what I would say. That's my summary for this.
Great, thank you so much, Prateek. And to add to that, yes, if you have questions after using artificial intelligence for this, please feel free to reach out to us. We're always happy to take a look at things for you. Thank you so much, Prateek. We will go
Thank
over
you.
to Maureen for cybersecurity compliance and risk management. Maureen, please tell us what steps a company can take to protect itself amidst increasing cybersecurity concerns.
So, hi, Arianna. I want to thank Prateek for all of his information. I think some of what I say during our discussion may kind of dovetail back into some of his comments as well. But in particular, for how a company can start to protect itself, it will really vary depending on the company and what kind of data it has, right? Um, does it have personal data? Has it looked at the laws that the data privacy laws to see how the data is defined in those laws to determine whether they have that information on their servers somewhere and collect it and or in paper form in their office? And if so, then you need to really start building a program for how to protect it and be in compliance with the laws that apply you. So oftentimes this is individual. It's not something that we would say all our clients need to take the same level of action. And then once they figure out that data, that company would want to review their insurance protections as far as liability. If there is any type of incident, they would want to monitor their technology systems or paper systems if the personal data that's protected by these privacy laws is contained either in their computer system or in paper files. It's really like an investigation into your own, like an audit of your own business and what kind of data you have. And it starts there and it can expand depending on what the company finds.
Absolutely, great points there. So should companies have a process in place for handling data breaches?
So this is a big yes, and it's because data breaches are becoming more common. Everyone is using technology more, so there's more data, and there's more likelihood that all of the companies will have data, personal data that they need to take action over to protect. So they should know about cybersecurity and they should have a process in place depending on their particular use of technology and the types of data that they maintain and store on their computer systems. Part of that process would include having a plan. I know Prateek mentioned processes. It would be a plan for responding to a potential security incident, right? You have to look ahead in order to protect yourself today. What if this happened to us? Not, oh, it's going to happen to other people. We're really secure. The question is really, it's going to happen. This is the way, from what I've seen and heard in the industries and with insurance companies, is it's not a matter of will it happen? It's more a matter of when, right? So you want to be prepared. And that includes having a crisis response team. Okay. This is a team that you appoint certain members and personnel within your company that would be the go-to. Hey, there's a security incident. You have a group of maybe 5 people that you pull together right away to look into this, right? And each of those members will have roles and responsibilities, and you treat it as an actual violation in order to take the appropriate measures, right? So the crisis response team, you assign roles and responsibilities to those people on the team, and then you have a plan for how to start the investigation and how to preserve any evidence as well. And then there'll be others involved as part of that team, which would be your insurance company representative, and as well as legal counsel.
Of course, yes, nobody wants to think about the data breaches, but it's best to be prepared for them. As you said, it's a matter of when and not if. So can you tell us what happens during an investigation?
So An investigation will vary with each company. As I said, it's very case specific, but generally you're going to pull in your crisis response team, your partners at your insurance company, your partners, whether it's inside counsel or outside counsel, law firm, and you'll look at what's going on. You'll ask questions and share information among your crisis response team. And then at a certain point, you may need to cooperate with partners that are involved, right? Um, if you're a company that collects data for one of your customers and it's your customer's data, you need to at some point inform them as part of the investigation. But again, you'll do that with guidance from legal counsel, with guidance from your IT team, and as well as your insurance representative. The questions that are raised in the investigation and will usually raise, and the information as it comes in will lead to more questions. So it's not going to be an easy answer. It's going to take some time, but you need to be patient and, foster trust and relationship with the people impacted by just trying to have some transparency while also protecting any privileged information.
Yes, and so being on the legal side of this, can you tell us what specific cybersecurity policies or frameworks courts look for when determining if a business acted reasonably?
So the courts will look to see if a company has a policy for cybersecurity. It will look to see how often it's updated or reviewed by the company to be most up to date for current tech concerns and data privacy concerns. It will also look whether the company has insurance to cover its business that's reasonable, and whether the company has been proactive in its policies for handling a potential data breach. It will also look into the appropriate safeguards that a company would have. So if a company has medical health information about individuals, that company really needs to be compliant with HIPAA and other US laws, as well as state and local laws. And you need to take appropriate administrative protections, technical protections, and physical safeguards to protect that data. And a lot of that might be you knowing that not everyone has access to that data. It's on a need to know basis. The courts will look at these types of factors as in assessing whether or not the company did enough to protect the data on a day-to-day basis.
Wow, so that sounds like it is very important to have that policy and make sure that it is regularly updated. Can you tell us what else courts might look at when assessing if a company was negligent or liable for damages resulting to an individual from a data breach?
So again, this is many facts that are involved in these sensitive situations. So including how did the investigation transpire? How soon did it start from when the company first learned of a potential incident? Did it take it seriously or did it just push it off for a week before pulling together the crisis response team? That time frame of like learning of an incident and pulling together the crisis response team should be within 24 hours or less. That's something that you should be prepared to do. So you need to have those are the proper chain of command in your response for that as well. You'll need to maintain discussions and document the discussions and decisions, not on handling data, but also in handling the investigation so that there is transparency. A lot of this will occur over phone calls because it goes really fast in the investigations, but you need someone there who will also track who's doing what when so that you can show the efforts were reasonable and diligent under the circumstances. And diligent is a really important aspect of like talking about the time response to investigate, to find out the problem, to protect from the problem becoming worse, and also to notice, to provide notice to the individuals affected if it's necessary. So those are all really important points.
Really good to know. So regarding individuals who might be harmed by a data breach, can you tell us what type of factors courts might look at to determine if an individual was harmed by a data breach and thus is entitled to damages for this?
So I'm going to talk about this at a high level. I'm not going to get into the nitty gritty because it is very specific for each type of data incident and data breach. But there are people that have tried to claim mental anguish and anxiety when they find out that their data was part of a data breach, right? And that is insufficient. It's an insufficient basis for damages. It's an insufficient basis for bringing a lawsuit. Just being named in a data breach and part of a data breach and just any anxiety over that is not an actual injury that the courts recognize. The loss of privacy as a result of the data breach, again, is insufficient. It's not enough just to be part of this data breach and say your privacy has been exposed, right? So it's not a concrete harm that's recognized by the courts. There's other damages that would be recoverable, and the idea of like actual fraud, such as identity theft and its impact on you. If your data was in a data breach and like just a month later or so, your identity was stolen, you need some proximate cause, like the events close in time. But also like that's an actual harm. There's fraud using your name for something that wasn't you and you didn't authorize. And so fraud or any monetary harm that results after the data breach could be a basis for an injury that the courts would recognize. Other things are including like monitoring your accounts. So a lot of companies will proactively offer to pay for account monitoring services to protect you as part of a settlement or as part of just being proactive and their side and the responsibility for the data breach. But if the company doesn't, and the person could go out and get their own account monitoring services and ask the company who had the data breach to compensate them for that. So just a few examples of the types of damages.
Great to know. Thank you for clarifying that for us. So how do cyber insurance policies interact with data breach liability, and what key exclusions should businesses be aware of?
So the cyber insurance company policies will define the terms somewhat different, maybe the same as the laws. It's something that you have to look at these terms that a data breach and personal identifiable information may vary depending on the law and the insurance policy. So you want to speak with your insurance representative, get someone who can really talk with you and explain things. Those insurance policies are very lengthy and I think difficult for most people to really understand. Excuse me, just partly because of the definitions, the use of the definitions in the actual language, and then addendums that might vary or create exclusions that have exclusions to the coverage that if you just read the coverage without looking at an addendum, you might interpret it differently. So you really want to know what your policy is going to cover and what it's not, right? Or if you have to pay for extra coverage for certain types of data privacy breaches. And again, this will really depend on the type of company that and the type of data that your business is holding on to and maintaining. So
great points there. Now, for the leaders of companies watching this, what role do company executives and boards play in cybersecurity accountability under current laws?
So I want to take this back a step and really talk about the laws. So the board has to be responsible on the company executives in implementing and supporting a crisis response team, right? You need to make sure in the budget, there's a budget for this. You need to make sure that you spend the resources on the technology. If upgrades are needed, then you need to authorize whoever's doing the day-to-day running of the technology and protection of your computer system, that they have the leeway to do what's necessary as risks change in technology all the time, that they have the tools to protect the company from these types of breaches. The laws and how they apply and interpret to actual, like the executives individually, it's not going to happen unless there's gross negligence or malfeasance in handling of these types of issues, which you usually won't see. Most people will try to be proactive because this is such an ever-present concern for companies. But one thing that the boards and the execs do decide as part of those who are part of the crisis response team or if the crisis response team is reporting to a board, one thing that I think they will be weighing in on is whether or not notice letters need to be sent to individuals, whether or not there is sufficient evidence to show whether there was a data breach or was it just a security incident that was wrapped up, identified, closed before anybody's data was actually breached. And so these are really nuanced questions. And just because there's a security incident doesn't mean it is a data breach that requires notice. And those are really sensitive conversations that you're going to have with the executives, with the board, and make a decision. And so it's really important to have that crisis response team and have a cooperative approach to it with the board, with the insurance company, and with your attorneys.
Very important information for our company heads here. And so much wonderful information today from both you and Prateek. I have one more question for you, Maureen. What else can a company do to protect against a data breach or to be prepared for a data incident when it happens? Your final piece of advice for us?
So I'll try to keep this short. I really appreciate all these questions and your time talking about this really important topic. I would suggest people go to the FTC, their website, ftc.gov, because they do have guidance for companies and how to prepare and what to do if there is a data breach. I would say just go there first, and if you have concerns, reach out to your crisis response team, reach out to your counsel. The U.S. Department of Health and Human Services, because of HIPAA and the concern for medical information, they also have guidance for breaches. And how to respond and how to be proactive. And so I would definitely direct everyone there as a starting point, just to educate yourself more so on what can happen. And then also look at your local and state laws. I'm sure, if you're not sure where to look, you can reach out to some technology people at your company may know, because they should be aware of all of this as well. And then, of course, we're always happy to do consults or speak with people about questions as they arise.
Absolutely. So many wonderful insights today. Thank you so much, Maureen and Prateek, for your time today to discuss this very important topic. That is all we have time for today. So this brings us to the end of our conversation. Thank you, everyone, for tuning in. A special thank you again to Maureen and Prateek. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, please send us an email anytime at info@truth.com. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again, Maureen and Prateek.
Thanks.